Okay, good day, everyone. Welcome to our part five discussion on the course, the law on partnership and corporation. We have finished part four. We have finished actually partnership. So we are going to start our discussion on corporation. So we are now on part five. Now I am your host, Lyndon Maceren, lawyer, a CPA or certified public accountant, and a real estate broker. And this discussion is intended for business law students. So the Corporation Code has been revised by Republic Act 11232. This was enacted in the 2018 and approved by the President on February 20, 2019. President Rodrigo Duterte. Now the uh, former or the uh, former corporation code was BP or Batas Pambansa 68. It was enacted in May 1, 1980. So now we are discussing the new or the revised corporation code. Now, most of the provisions of this code was taken from that former law. So we begin our discussion with the definition of corporation, which is stated in section 2 of the code. And a corporation is defined as an artificial being created by operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or incident to its existence. Now, the definition of the corporation consists the attributes of a corporation. And there are four, which is number one, corporation is an artificial being, meaning it is a person. Once the second attribute, which is created by operation of law, once this the agency or the commission, which is the Securities Exchange Commission, in charge of issuing the certificate of incorporation. So once they issue the certificate of incorporation to an applying organization, it becomes an artificial being. So the first attribute, it is an artificial being, meaning it can be sued, it can sue, it can own properties, it can hire employees, it can conduct a legal business. Now it is created by operation of law. I have already discussed this, since it needs the imprimatur of the state, meaning it cannot uh, commence its artificial being or its life as a juridical person without the certificate being issued by the commission. The third attribute is the right of succession. This is the right of a corporation to continue its life despite changes in the stockholders. Meaning, if a stockholder dies, the corporation continues its life. Unlike in partnership, when a partner dies, the partnership will be subjected to dissolution. And the last attribute, which is the powers, attributes, and properties expressly authorized by law. So meaning the the corporation can only exercise those powers which are stated in its certificate or the bylaws, or which are only incidental to its existence. So as an artificial being, it is subject to certain limitations. Now, a corporation cannot commit felonies. What are felonies? Well, felonies are those crimes which are discussed or defined in the revised penal code, which is our criminal code here in the Philippines, the revised penal code. So corporations are incapable of requisite intent to commit crimes. It cannot commit crimes that are punishable under special laws also. So special laws are new laws outside the revised penal code because crimes are personal in nature and requires only personal performance or overt acts. So the penalty of imprisonment to a corporation cannot be imposed. So who can commit only crimes or felonies? These are only uh, natural persons. So corporations lack the intent to commit crimes. Further, a corporation cannot be awarded moral damages. In some cases, a corporation would file a case before a court and ask for moral damages. So the Supreme Court has ruled in the case of ABS CBN versus Court of Appeals, this was in 1989, that the award of moral damages cannot be granted in favor of a corporation because it is an artificial being, meaning it has no emotion, no feelings, no senses. It cannot therefore experience a physical injury. So there should be injury or harm. So it can uh, corporation cannot experience physical injury or harm. So moral damages cannot be awarded to a corporation. Although generally the corporation is in by itself a separate being from its stockholders, also the directors. So this legal fiction is certain instances disregarded. So there is what you call the doctrine of piercing the veil of corporate fiction. So this is to uh, determine who owns the corporation. So piercing the veil of corporate fiction means that while the corporation cannot be generally held liable for acts or liabilities of its stockholders or members and vice versa, because the corporation is personal, separate, and distinct from its members or stockholders. However, the corporate existence is disregarded under the doctrine of piercing the veil when the corporation is formed or used for illegitimate purposes, meaning for illegal purposes, and particularly as a shield to perpetuate fraud, defeat public convenience, justify a wrong, evade a just and valid obligation, or defend a crime. Now, in the case of Francisco versus Mejia, the doctrine of piercing the veil has been pronounced by the court. And in this case, the court says that mere ownership by a single stockholder or by another corporation of all or substantially all of the capital stock of the corporation does not justify the application of the doctrine. So there must be other circumstances that must be present. Now, these are the elements that must be present to justify piercing on the ground that the corporation is a mere alter ego. So, before we proceed with the discussion, I'll tell you when this happens. So let's say, for example, there's a corporation operating a restaurant and there are employees in the restaurant. Now, the employees wanted to have higher salaries, so they are negotiating with the corporation, but unfortunately, the corporation is not yielding to the demands of the employees. So the employee stages strike. And when the employee stages strike, now the corporation, the restaurant operations was on halt or stop. Hunong, no? So because the all the employees of the restaurant were on strike. This includes the chef, the waiters, the waitresses, the cashiers, and all employees. So what happened? The corporation decided to sell the restaurant and all its assets because the employees already filed a case in the labor. You know? So what happened? It was sold to another corporation, and the new corporation now decided to uh, commence or restart its business operations. And then while the employees are still filing a case, I mean the employee is giving now is getting the decision of the case of their uh, demands before a labor court. The labor court has favored the employees, no? So they won in that case. And in that case, the employees were given by the court uh, paybacks or back pays, no? Meaning on the months that they have not worked, they should be given fees or their salaries. But the new corporation now is not willing to pay. So, but the employees states that this new corporation who owns now the restaurant are still owned by the same uh, stockholders in that old corporation. So now we use the doctrine of piercing the veil of corporate entity to identify the stockholders or the officers of this new corporation. And it was found out that the new corporation is still owned by the same set of stockholders or incorporators in that old corporation. So they're just forming a new corporation to get away with their liability to pay the employees for their back pays. So these are now the elements that must be present to justify the piercing of the veil on the ground that the corporation is a mere alter ego. Alter ego is that it's the same person just making another corporation. So number one, control. So not mere stock control, but complete domination. So not only of finances, but of policy and business practice in respect to the transaction attacked, and must have been such that the corporate entity as to this transaction had at the time no separate mind, will, or existence of its own. Number two, such control must have been used by the defendant to commit a fraud or wrong to perpetuate the violation of a statutory or other positive legal breach of duty, or the dishonest and unjust act in contravention of a plaintiff's legal right. And the said control, number three, and breach of duty must have approximately caused the injury or unjust loss complained of. So that's why if there are two corporations and there are the same set of owners and they're just forming another corporation to get away with a legal obligation, so we use this doctrine. We pierce the veil to know if the owners are the same. So further, there are circumstances that may indicate that piercing the doctrine should be applied. Number one, the parent corporation owns all or most of the capital of the subsidiary. See, there are two corporations here, the parent and the subsidiary. Number two, the parent and the subsidiary corporations have common directors or officers. So common directors or officers. Number three, the parent company finances the subsidiary. Number four, the parent company subscribed to all the capital stock of the subsidiary or otherwise causes its incorporation. Number five, the subsidiary has grossly inadequate capital. Number six, the subsidiary has substantially no business except with the parent corporation or no assets except those conveyed to or by the parent corporation. Number seven, the papers of the parent corporation or the statements of its officers, the subsidiary is described as a department or a division of the parent corporation, or its business or finances, financial responsibility is referred to as the parent corporation's own. Number eight, the parent corporation uses the property of the subsidiary as its own. Number 9, the directors or the executives of the subsidiary do not act independently in the interest of subsidiary, but take their orders from the parent corporation. And number 10, the formal legal requirements of the subsidiary are not observed. Now, this was decided by the Supreme Court in the case of Philippine National Bank versus Retrato Group Incorporated, way back in 2001. Now, at this point, we will discuss the cases which established the delineation of ownership over properties between the corporation and its stockholders. Now, in the case of PNB versus Andrada Electric and Engineering Company, the court decided that a corporation may also own its own property. Note that the property it owns does not by any means belong to the stockholders. And the stockholders thus have no interest in such corporate properties. So conversely, the corporation also has no interest in the properties of the stockholder. So it's very clear. The corporate properties does not belong to the stockholders, nor the stockholders own the corporate properties. In another case, the Weiss versus Mansung Lung, the court decided that the corporation is entitled to own properties in its own name, and its properties are not the properties of stockholders, directors, and officers. So meaning there are separate ownership. So taxes of the corporation should be paid by the corporation, and taxes of the stockholders, directors, officers should be paid by them because there are different ownerships. Another case, Saul versus Court of Appeals, the court decided that the interest of stockholder over the properties of the corporation is merely inchoate, meaning it's still not ripe. No, it's just a title, inchoate, and it does not ripen into full ownership because ownership is broken into usufructuary and owner title, yeah. Possession and title. So as a consequence of this delineation between properties of the corporation and stockholders, liquidating dividends may be made subject to taxation. See, as I have said earlier, that the taxes of the corporation should be paid by the corporation. In another case, Guanson and Sons versus Register of Deeds of Manila, the court says that these are the facts. No, a corporation was dissolved, and its properties conveyed to the stockholders as liquidating dividends. So the government is claiming that they are liable for tax on the gain of the individuals. So meaning the stockholders gained properties by way of liquidating dividends. So these liquidating dividends are dividends given on the process where the corporation is subjected to liquidation. So they are selling their assets or converting assets into cash. So instead of giving cash as dividends, the corporation is giving properties as dividends, so liquidating dividends. But in this case, when the BIR demanded for payment of liquidating dividend tax, so tax as a gain on the stockholders, the stockholders refused to pay the taxes on the ground that there was no conveyance of property. They said that the property they received was merely a case of partitioning their own. No? The stockholder says that, oh, these are our own properties. It's just that the corporation is now returning the properties to us. So there is actually no gain. No? So the issue now is whether or not there is a taxable transaction, whether or not the transfer of property from the corporation to the stockholder in the by way of liquidating dividends is a taxable transaction. So the Supreme Court held that the properties which were given as liquidating dividends do not belong to the stockholders, but they belong to the corporation. So hence, upon distribution via liquidating dividends, there was a conveyance and consequently a taxable transaction. So conveyance is transfer of ownership. So there was a transfer of ownership. So Supreme Court says that you should pay tax. Why? Because the property of the corporation is different from the property of the stockholders. It's not owned by the stockholders, but it is the corporation who owns them. Okay, now we will discuss the grandfather rule. What is the grandfather rule? The grandfather rule is applied in determining the nationality of a corporation. Oh, wait a minute, we have to discuss this one. Now we will discuss the nationality of a corporation. How do we determine the nationality of a corporation? Now, laws and jurisprudence would provide the following tests. The first one is the incorporation test. This is determined by the place of the incorporation, regardless of the nationality of its stockholders. So if the corporation was incorporated here in the Philippines, but the stockholders are foreigners, so the nationality, therefore, of the corporation is a Filipino. Why? Because it is incorporated here in the Philippines. Number two, it is the domiciliary test. This is determined by the principal place of business of the corporation. So if the corporation is doing business here in the Philippines, even though it's incorporated in the United States, it can be said that its nationality is a Filipino. Why? Because its principal place of business is here in the Philippines. Number three, the control test. This is determined by the nationality of the controlling stockholders or members. So if the stockholders or members, the controlling stockholders or members are Filipino, then the nationality of the corporation is Filipino. So if you note, there are two here, stockholders or members. Stockholders are those which are shareholders of stocks in a stock corporation, while members are for non-stock corporation. And lastly, the grandfather rule. This is the test of nationality to the percentage of equity in the corporation used in nationalized or partly nationalized area. So nationalized meaning there are businesses which are constitution mandates that it should be operated only by Filipino citizens, no? Or corporations at least owned by 60% of which is owned by Filipinos, like mining, for instance, like media, no? Newspapers, television. It should be 100% Filipino. Now, the grandfather rule is the method by which the percentage of Filipino equity in the corporation engaged in nationalized or partly nationalized areas of activities provided for under the Constitution and other nationalization laws is computed in cases where corporate shareholders are present by attributing the nationality of the second or even subsequent tier of ownership to determine the nationality of the corporate shareholder. So this rule is applied specifically in cases where the corporation has corporate stockholders with alien stockholdings. Otherwise, if the rule is not applied, the presence of such corporate stockholders could diminish the effective control of Filipinos. So meaning the grandfather rule should be applied to determine that this corporation is a Filipino corporation. And because this corporation is engaged in the business of nationalized or partly nationalized businesses.